We're back with another very last minute live stream. Thanks you guys for hanging around. That was kind of fun, that dig. I really thought I had hope that we were going to find something, but they just didn't. They just didn't. But it was fun while it lasted, wasn't it? I thought so. I had a good time. So I have some documents here from the attorneys for Brian Walsh that I wanted to go over with you. So we can see what they're demanding regarding Michael Proctor, because that's interesting and fun. And we have started covering the Brian Walsh case, so we're going to continue to cover it. And these papers, most of which were filed September 24th, which was like the day before the hearing that we watched, I believe, maybe even the same day. And then we also have some papers from the Commonwealth of Massachusetts regarding Brian Walsh. So there's some discovery exchanges, and they talked about him during the hearing that we watched, but we didn't have the papers, but now I found the papers. So that's what we're going to do. I know there's so many things to cover right now. I got to do the Kevin Gregg interview. There's some stuff that came out on the Menendez brothers and Gascon, the DA of Florida. Los Angeles came out and said some stuff about the Menendez brothers, and they're going to look into it. We got Kevin Gregg. There's just too much stuff right now to cover. Here's what happens. Like, the summer is dead for courts, pretty much. I mean, we did have a pretty active summer. But remember, the Karen Reed trial ended like beginning of July. Then it was kind of dead, and now everything is coming back. So everything is now coming back, and there's too many things almost to cover. I know, which is why I need to split it up into like 3 streams a day. I should just be like Peter Tragos and just try and keep them to an hour and 15. But I talk too much. And there's not. I feel like the stuff that we talk about, it like you can't cover it in an hour and 15 minutes, right? You just can't. But Kelly Reed just sent me something on Proctor. So let's pull that up and look at that first. And I think it's from, this is the Boston Herald. Let me see. It is from the Boston Herald. And for a lot of people, Boston Herald is behind a paywall. So thank Kelly Reed for getting us in on it. Because what had happened was it in the Brian Walsh papers or in the Turk papers? I think it was the Walsh papers. I think maybe we'll come on this today. An attorney said that Michael Proctor had been terminated. Proctor Trupa had been terminated. And I said, even when I saw it, I'm like, I don't know, maybe that's a typo. But apparently we don't know if he's fired or not. But let's see, because I haven't read this yet. So let's pull this up and read what the Boston Herald has to say about it. Let us see. And I assume this is from today. It says, sorry, disgraced trooper still paid. And there's a good old nice picture of Proctor there. So I will put on my best ASMR voice and read it to you, as I do. Except I need to make it a little bit smaller because then it gets blurry. Oh, it wasn't Brian Walsh, because here it is. Proctor Trupa. Single line in a defense filing in the Brian Walsh murder case, is Karen Reed case fanatics reeling. Was Trooper Michael Proctor, the case officer for both, fired from Massachusetts State Police? Who's this author? His name is Flint McColgan. And he's calling him a case officer, but we know, because we know he was the lead investigator. They demoted him during the trial to case investigator, customer service representative, or any other phrase that you would like to use. It's entitled, sorry, disgraced trooper still paid. There is a court filing in the Walsh case that is not correct. Trooper Proctor remains on unpaid leave as he awaits the outcome of an internal affairs investigation, MSP spokesman Timothy McGurk told the Herald today. Hot off the presses, folks. The confusion comes from a filing by Walsh defense attorney Larry Tipton, who made an error in his summary of the career trajectory of Proctor. Proctor was almost immediately placed on leave when the Reed trial earlier this year ended in a mistrial as behavior that he admitted was extremely unprofessional came to light when he took the stand in that case. He was later suspended without pay, but has not been outright fired from the organization. The Proctor debacle, the Proctor debacle. So we should just call it the Proctor debacle. Resulted in Proctor being first suspended and then terminated from the state police, but only after defense counsel exposed the serious issues, Tipton wrote in a filing. The filing, as the Herald reported, requests that the Walsh defense team be provided with the contents of Proctor's work phone and cloud account that could provide some exculpatory evidence for Walsh. Norfolk County prosecutors filed notices earlier this year in this and other cases Proctor worked that the DA's office had received an extraction from Proctor's phone and closed, what does that say? And cloud account, and that the materials could impact these cases. I'm just going to break for a minute to say, what are the odds that Proctor Trooper might have been looking for nudes of Anna Walsh and Brian Walsh's phone? If it was a thing, Anna Walsh, her body hasn't been found, but they're assuming that she is deceased because he's being charged with her murder. Stunningly beautiful woman. Was it a thing? I don't know. Wouldn't that be crazy if that came out? Just, hypothesizing here, spitballing with you, brainstorming. Walsh, 49, is charged with the murder of his wife, Anna Walsh, who the prosecutors say he slayed and then cut up on the first day of 2023 and then hid her body parts in dumpsters around Greater Boston. Since being indicted for her murder, he was sentenced in federal court to an unrelated international art fraud case, which he has appealed. He has been detained at the Norfolk House of Correction since his initial arrest. Reed, 44, of Mansfield, is charged with second-degree murder, motor vehicle manslaughter, and leaving the scene of a collision causing death of John O'Keefe, the 16-year member of the Boston police force, and Reed's boyfriend of 2 years, in the early morning of January 29th, 2022. So the disappearance of Anna Walsh and the arrest of Brian Walsh came almost exactly 1 year later, January of 2023. What goes on in Norfolk County in the winter with all these blizzards? Honestly has an opinion. Honestly, Proctor was definitely looking for nudes. Tim says Walsh wouldn't talk to Aiden. Did Aiden get a hold of him and he just said, no, I don't want to talk to you? Don't come to Massachusetts in January, my friends. Do not. Please hit the like button. Thank you, Scott. 1,299. When one more person joins, we'll be at 1,300. So yeah, just, I'll just chit chat for a minute, give you a chance to check up and a chance to, as such, hit that like button because it is the nice thing to do. And then right after that in the Herald, they have an article called Karen Reed Seeks to Freeze the Civil Case. Were they watching me? Because I covered it first, I think. Pretty sure I did. Love that. Love how all these court TV and law and crime, they're all trying to get Bridget Todd to come on their show. Carly Gregg's attorney. And she's like, no. And they're like, but you did 2 other interviews and they were both mine. And, Nancy Grace and Bridget's like, and then they try and tell her, well, we have a lot more views and a lot more subscribers than she does, talking about me. Bridget's like, yeah, no. Because she knows what she's going to get when she comes on my show. And I'm not going to be mean to her. I saw Nancy Grace interviewing somebody the other day. It was like a guest that she invited on. And she was so mean to the guest. I was like, what are you doing? Is this scripted? What is going on? So yeah, so there's that. So I got that going for me today. Here we go. This is the Commonwealth's notice regarding State Trooper Michael Proctor's work phone data, and this was turned over to the defense on September 6th. In the Commonwealth versus Brian Walshe. I have done at least one show on this case. I think just one. So this is really only stream number 2. So you're not missing too much. You only have one stream, I think, to catch up on. Coincidentally, the Brian Walshe case is also being heard by Judge Beverly Canone. So we did see a conference with her the other day, and a lot of you had PTSD just from hearing the voice. So there you go. Brian Walshe is being tried in front of Judge Canone for now, anyway. Thanks, Andrea, for thanking me for talking a lot today. I know that's a lot. I want to gift you a Singapore cap, Melanie. I don't know what that is, but I don't have an address. Your presence is my present. No worries. Thank you, Sandra, for tuning in from Singapore. Thanks, Kes Chick, for hanging with me for 4 months. Sometimes I see. I gotta say, Vinny did a very kind show about Carly Gregg after I had Bridget on twice, as did even Julie Grant. I couldn't believe it. Okay, let's not try and digress too much, because we have so much to cover here on Brian Walshe. If we start talking about too many cases, we're not going to get anything done. Here's the Commonwealth's notice regarding State Trooper Michael Proctor's work phone data. I'm going to be reading, so I'm not going to be watching the chat. So please do not try and shout at me in the chat to see your comments, because I'm not going to see them, because I have to enlarge this and the chat closes out. Please also note this is my cursor on your screen, not a fly. Don't kill it. In January of 2023, and this is from the Commonwealth to the defense attorney on Walshe. In January of 2023, Trooper Michael Proctor was designated as the case officer in the missing person and murder investigation of Anna Walshe by the Massachusetts State Police. How much do you want to bet he was called lead investigator and not case officer in 2023? The Cohasset Police designated Sergeant Harrison Schmidt in an identical role. See what they're doing here? They're like, yeah, you're not going to need Proctor at your trial, because Sergeant Harrison Schmidt of the Cohasset PD, he had the same identical role as Michael Proctor. So no big whoop that you can't use Proctor, because this guy did the same thing. They were co-lead investigators. Listen to the choice of words. What they don't say is just as important as what they say. And the words that they choose, because as I tell you every single time, lawyers pick their words very carefully. Word choice is huge for a lawyer. The Massachusetts State Police and the Cohasset Police devoted dozens of additional officers to the investigation. It's a little bit bigger. Indictments issued on March 31, 2023. As of the time of this filing, the Commonwealth does not intend to call Michael Proctor to testify in this matter. But guess who can? The defense. And wouldn't you? If you were the defense, and then he becomes an open book and you get to cross-examine him about all the BS that went on in the Karen Reed case, all the looking for nudes. And I would ask him that too. Oh, so Trooper Proctor, or he may not be a trooper by then, Mr. Proctor, you got a hold of my client's phone, right? Brian Walsh, you got a hold of his phone, right? Did you look through the photos? Were you looking for nudes of Anna Walsh? Crazy, right? The trial of Commonwealth v. Karen Reed began in Norfolk Superior Court on April 16th of 2024. Beverly J. Canone presiding. Trooper Proctor testified in that matter on June 10th and 12th, 2024, and was subject to cross-examination relating to the alleged conflicts of interest, communications with non-involved civilian persons regarding the Reed case. Yeah, all of his buddies from like middle school and high school who said to him, "Oh man, that homeowner's going to catch some heat, right?" And he was like, "Nope." Members, put some nope emojis in the chat because we made a nope emoji just for that. Nope. He's a Boston cop too. We're going to pin it on the girl. Those are the civilian persons, the non-involved civilian persons that he was talking to about the Karen Reed case. And statements regarding the defendant from which defense counsel argued a bias could be found. Would you not absolutely say there was a bias found when you call the girl a whack job with a leaky blank blank? Bias much? And you wish that she would just take her own life? Which is kind of ironic considering that when Trooper Reno got on the stand, he did say at one point, "Kill me," when he was presented with some text messages that he likely missed during his extraction of Karen Reed's phone. And it'll be interesting to see if Trooper Guarino, was involved with the cell phone extraction of Brian Walsh, because he was involved with the cell phone extraction of Matthew Farwell, the police officer who impregnated and then murdered Sandra Birchmore, and he couldn't find 32,000 text messages on Matthew Farwell's phone, Stoughton police officer Matthew Farwell's phone. So they ruled Sandra Birchmore's death a suicide within 3 hours. They closed that case. So there's that. On August 14th, 2024, the Commonwealth provided an unofficial transcript of Trooper Proctor's testimony in Reed to counsel. Also, the Commonwealth provided counsel with a letter disclosing the results of its inquiries pursuant to Graham and McFarlane, which included that Trooper Proctor had been suspended without pay. On August 29th of 2024, Massachusetts State Police provided an extraction of Trooper Proctor's work cell phone to the Norfolk District Attorney's Office. On September 4th, 2024, the Massachusetts State Police provided content from Trooper's work cloud account to the Norfolk District Attorney's Office. Based on the Norfolk District Attorney's Office preliminary review of the data, and because the extraction of the Proctor work phone and cloud is expected to contain, among other things, information about open investigations, surveillance video from unrelated investigations, personal identifying information, and or medical information of individuals involved in unrelated investigations, location data of Proctor and third parties. Releasing the entire extraction report outside of law enforcement is anticipated to jeopardize open investigations, compromise the privacy and safety of civilians. 1 second. And thus be contrary to the interests of justice. Footnote 1, which reads, the phone and cloud account may include sensitive and confidential communications and information regarding unrelated cases and active investigations. This information may include criminal offender record information, CORI, The names and contact information of confidential informants, names and contact information of civilian witnesses and victims, including minors, impounded search warrants, status updates of covert ongoing investigations, information about ongoing grand jury proceedings, autopsy records and photographs, and other sensitive privileged information that, if disclosed, would not only jeopardize law enforcement efforts, but could pose as a physical safety risk to individuals and the public alike, citing some case law. A defendant's unrestrained access to these devices would also likely violate statutory privileges serving to protect unrelated cases, investigations, witnesses, and victims. See GL Section 41. Additionally, the professional device of a municipal or state employee could include sensitive personnel information about that person, such human resources documentation, payroll information, i.e., bank account numbers, personal identifying information such as social security numbers and home addresses, and sensitive medical information, all of which is statutorily exempt from public disclosure. Accordingly, the Norfolk District Attorney's Office is in the process of ascertaining how to determine what, if any. Oh, we have a what if any emoji. Remember, I made that during the trial too. Hold on. What, if any, information on Trooper Proctor's work phone or cloud account is discoverable in this or other cases? Because there are other cases that Trooper Michael Proctor was the customer service representative on, and now that he's on the Brady list, poses a problem for the Commonwealth. Footnote number 2 says the Norfolk District Attorney's Office is exploring hiring an outside firm to examine the phone and cloud data to ascertain what information is discoverable. On September 6th of 2024, a Zoom hearing was held in Commonwealth v. Julius Hammond this year and Samantha Schwartz. The Commonwealth reported that it was in possession of Trooper Michael Proctor's work phone and cloud. The Commonwealth indicated it was exploring whether to hire an independent firm to examine the phone and cloud data. Both the court, Judge Peter Krupp, and the defense indicated that it was their position that the Norfolk District Attorney's Office has the obligation to conduct a search of the phone extraction. Does anybody know about that case? Commonwealth versus Julius Hammond Dacier and Samantha Schwartz. I mean, listen, we could just have Norfolk County content creation forever. It seems there's no end to the cases that we could cover in that county alone. Accordingly, in the Commonwealth versus Julius Hammond Dacier and Samantha Schwartz, the Norfolk District Attorney's Office will follow the court's direction and search the data for bias and Rule 14 materials. The Commonwealth would be willing and able to conduct similar searches for this case. The Norfolk District Attorney's Office also intends to continue to explore retaining an independent firm to review and examine the materials. I mean, do you really think that we should, trust the fox guarding the henhouse? I mean, look, they can't even trust Lally to retry Karen Reed. They had to go hire Whitey Bulger's defense attorney, Hank Brennan, to come out of private practice. And they just entered into a $75,000 contract with Hank Brennan at $250 an hour to retry Karen Reed. We went over that last night. Was that yesterday? I don't even know what day it is anymore. I think it was yesterday. You guys are the funniest chat on YouTube, so keep it going. Although, as Team Brittany will remind you, one of my amazing moderators, post responsibly. Your opinions are your own. No legal or professional advice of any kind is given out here. Welcome, everyone. Right. So do you trust them to do their own inspection? Because, if we were the trusting kind, we would have trusted that the Canton Sallyport video that they had Trooper Yuri Buchanan or Bukwacki testify to was a fair and accurate representation of the way Karen Reed's Lexus looked in the Sallyport on the evening of whatever, when in fact, only on cross-examination did come out that, oh, the video is mirrored. So the passenger side really looked like the driver's side, and the driver's side really looked like the passenger side. So how can we trust them, we the public? Hi, Lily Rose. Lily Rose, $250 is not a stand-up. That is a low ball. That is a low ball. I covered this yesterday, but I will cover it briefly again with you. Norfolk District Attorney's Office has hired Hank Brennan, Esquire, criminal defense attorney to the likes of Whitey Bulger, to come in as a special ADA to re-prosecute the Karen Reed case at $250 an hour for a cap with a cap of $75,000. That is a bargain basement price. We're going to TJ Marshalls, TJ Maxx and Marshalls for that price. Okay. I don't know what the going rate is for lawyers in Boston, but I would imagine some of them charge north of $750 an hour. If you're in LA right now and you're paying for a divorce lawyer, you're probably paying $1,500 an hour. At $75,000, that is 300 hours of work. I would submit to you, and this contract, by the way, runs through June of 2025. 300 hours. If he worked 8 hours a day, the 300 hours would only be 7.5 weeks of work. And that would take him through Thanksgiving. This case isn't even not allowed to. It's not supposed to start until January 27th of 2025. So are they going to keep renewing his contract? No. 250 is bargain basement. Bargain basement prices. I don't know why he would leave his private practice to do that. Does he want to run for district attorney? And this is his foot in the door? I don't know. But it is very unusual, as Betterow has said on my show, to call a defense attorney to come in and prosecute. Most prosecutors, after they retire or leave their district attorney's office, become defense attorneys, like Betterow did, like Alan Jackson did. Very rare that they go back to prosecuting when they already have a successful defense firm. So kind of weird, right? In my opinion. So this was sent to defense counsel Larry Tipton, September 6th of 2024. This was filed September 24th of 2024. So I just want to just do a little check here of what day that was that I did that stream with you, because it was a live stream and it was of the Brian Walshe hearing. And I've done so much since then on other cases that I forgot. So let's see, that Brian Walshe stream was on October 2nd. So that was like 2 days ago. Man, it feels like a year ago. Today's Friday, so that would have been Wednesday that we covered that live hearing. This was filed by the defendant, Brian Walsh's counsel, on September 24th. So this is all relatively recent stuff. And this is a motion for discovery of documents related to the district attorney and law enforcement. Make it bigger for you. God save the Commonwealth. Now comes counsel for the defendant, Brian Walshe, and respectfully requests that the Commonwealth, 1, inquire and disclose the following information, and 2, if such information contains what it is considered confidential or protected information, that it be produced pursuant to a protective order, and 3, if after proper inquiry to acknowledge such inquiry for any category listed below where it was determined that no such information existed, so they want them to either turn this stuff over or say, no, it doesn't exist. Those are your choices. Turn it over. Ask for a protective order for anything you think is considered confidential or protected information. Or say that it doesn't exist. You got 3 choices. God save us from the Commonwealth. Oh, Debbie Jo coming in. Cooler says, what if someone owed someone else a favor and repaid it by prosecuting a case? Could it be? Could be. Hmm, I don't know. Here's what they're looking for. Number one, a complete copy of all data referred to in the Commonwealth's notice dated September 6, which we just read, 2024, described as an extraction of Trooper Proctor's work cell phone and Trooper Proctor's work cloud account. Two, a complete copy of an estimated 3,074 pages of materials and documents provided by the Department of Justice to the Norfolk County District Attorney's Office regarding its investigation into the death of Officer John O'Keefe. Oh, they want that document dump. I did a whole stream on that. It's in the pretrial Karen Read playlist. Three, a complete copy of all correspondence between the DOJ and the Norfolk County District Attorney's Office regarding its investigation into the death of Officer John O'Keefe. Well, you can just come to my channel and find them. We did a whole stream on that too. Unless there's more letters that we don't know about. A complete copy of any documents, correspondence received from the U.S. Attorney or any other federal agency concerning the Norfolk County District Attorney's Office's investigation into the death of Sandra Birchmore. Five, a complete copy of any documents and materials regarding the policy, protocols, or agreements, including any memorandum of understanding between the Massachusetts State Police and the Norfolk County District Attorney's Office related to the assignment of state police to that office. That's interesting. Six, any and all notes, reports, memoranda, or other documents related to the investigation of State Trooper Michael Proctor and his conduct in investigating the death of Officer John O'Keefe and the whereabouts of Anna Walshe, including but not limited to the following. A, notes, records, memoranda, or other documents concerning Proctor's job performance. B, notes, records, memoranda, or other documents concerning disciplinary actions, formal or informal, of Proctor. C, notes, records, memoranda, or other documents concerning complaints or any similar communication from any party concerning the conduct of Proctor. They want all the complaints. Wonder if they have complaints. D, notes, records, memoranda, or other documents concerning the supervision of Proctor by the state police, the Commonwealth, or any of its agents. E, notes, record, memoranda, or any other documents containing information of any person, including state police, local police, investigator, or forensic consultant supervised by or required to report directly to Proctor. Oh, yes. Oh, yes. Oh, yes. I am serious. They are paying him $75,000 to retry Karen Read. Yes, they are. Because apparently none of the attorneys that they have working on staff, the Norfolk County DA's office, are either good enough or they don't want to touch it. Seven. Something just happened with my mic. Okay. 7, any and all internal affairs records, memoranda, or other documents regarding Proctor. 8, any and all policies, protocols, directives, or memorandum of understanding regarding the supervision of state police assigned to the Norfolk County District Attorney's Office. 9, any and all notes of all state police and any member of the Cohasset Police Department involved in the investigation of this matter concerning the investigation of this matter. Well, what we did learn from the Karen Read trial is that nobody keeps notes. Because they asked for notes in the Karen Read case too, and they said, yeah, no, we don't have any. There's no notes. No notes. Apparently Proctor, drafts his witness statements months later from memory. They don't take notes. It'll be interesting to see if the Cohasset Police Department takes notes. I don't know anything about the Cohasset PD. If anybody here is a Cohasset local, tell me. Do you trust your PD? Are they good? 10, any and all notes, reports, memoranda, or other documents containing information concerning the investigation of this matter that have not thus far been provided as of the filing of this motion. 11, any and all notes, reports, memoranda, or other documents concerning interviews or conversations with prospective grand jury witnesses, regardless of whether regardless of whether the witness was in fact called to testify before the grand jury in this matter. 12, any and all notes, reports, memoranda, or other documents from any victim advocate concerning any information concerning the investigation of this case or the disappearance of Anna Walsh. Well, that's interesting because there had been some chatter during the Karen Reed trial. Perhaps the victim witness advocate in the Karen Reed case may have been involved in telling, Higgins and Proctor, or to destroy Higgins and Brian Albert, that they could destroy their phones, right? Tell me what the victim witness advocate, refresh my recollection, chat, if you will, about what the victim witness advocate, Steve Nelson, I think his name was, in the Karen Reed trial, what he was sort of involved in. Was it the destruction of the phones? Did somebody actually get on the stand and like point to him and say, oh yeah, he's the one who told me I could destroy my phone? Let me know. 13, any all notes, reports, memoranda of other documents containing any reference to leads arising in the investigation of this matter of persons who are or were considered as targets, suspects, or third-party culprits, regardless of the outcome of any investigation and regardless of whether such persons were ever investigated. Steve Nelson, yeah. Oh, Sidney Collin, wasn't Enrique a victim witness advocate? He was, right? In Worcester, right? And that's why the Worcester County DA recused. He said, we all know Enrique here. We all love Enrique here. Huh. I'm just looking at the chat here to see if you guys have. That's what I thought, Team Brittany. I thought it was him who said Higgins didn't have to follow the preservation order. Huh. Rosemary Gallagher says, yes. Well, Enrique wasn't he in Worcester County? So I don't think that this has anything to do with him, but we were just pointing that out. He was a victim as advocate, yes, in Worcester. Thank you, Adam Lally's resignation. Has your name come true yet? Nope. Okay, so they want everything regarding any targets, suspects, third-party culprits, regardless of whether they were ever investigated. 14, any and all notes, reports, memoranda, or other documents concerning communications of the state police, any member of the Cohasset Police Department, any person at a different police department, federal law enforcement, and any agent of the Commonwealth and the district attorney for Norfolk County concerning the investigation of this case. 15, any and all cellular telephone records in the possession of the Commonwealth or its agents of any state police and any member of the Cohasset Police Department involved in the investigation of this matter. And that's, I guess, if they're in possession of it. I don't know, you guys. I tried what you said. I tried turning off my phone and then turning it back on and then trying to get it to work, but still, and it's only on my particular streams when I'm on my lives, I cannot sort the top messages and all messages. Like that little like thing doesn't even come up where you can toggle it. I don't know. I don't know what it is. "16, any and all text messages in the possession of the Commonwealth or its agents of any state police and any member of the Cohasset PD involved in the investigation of this matter. And 17, any and all social media records in the possession of the Commonwealth or its agents of any state police and any member of the Cohasset Police Department involved in the investigation of this matter. 18. Finally, the defendant requests that if it is determined that no information in any of the above categories was deleted, destroyed, or lost, the Commonwealth inform counsel of that conclusion, including the time, place, manner, and means of the circumstances of any deletion, destruction, or loss of the information. Isn't it so sad that defense attorneys now have to put out demands like this in Norfolk County? When the Massachusetts State Police was involved in the investigation of an unattended death. As grounds, therefore, the defendant asserts that the request for inquiry and disclosure as requested is necessary for the adequate preparation of the trial of this matter for the reasons set forth in the attached memorandum of law and fact. In summary here, these requests are based on the revelations of bias and a lack of proper supervision of the state police assigned to the Norfolk District Attorney's Office. The biased statements of Trooper Michael Proctor, the DOJ investigation into the handling of the death investigation of Officer John O'Keefe. Thank you for calling him Officer John O'Keefe. Counsel, thank you for that, my brother. Remember that one hearing, we heard it. Attorneys in Massachusetts call other attorneys, my brother, my sister. We heard it in one pretrial Karen Reed hearing, then we heard it again recently in another case where he called him my brother. I think it was at Aidan Carney's hearing. I think it was Bradel who said my brother about the opposing attorney, his adversary. Sometimes it comes up. So thank you, my brother, for calling Officer John O'Keefe an officer, which nobody else did in the Karen Reed case. The production of the 3,072 pages of documents produced to certain parties regarding that death investigation, the fact that portions of correspondence between the DOJ and the Norfolk County District Attorney's Office has been released, that the Commonwealth has received digital data regarding Trooper Michael Proctor, and the troubling emerging facts and circumstances regarding the Norfolk County District Attorney's investigation into the death of Sandra Birchmore. Yes, Anthony. Anthony, it's Prince Spaghetti Day. Now I'm really dating myself. Do you guys remember that commercial? Anthony, it's Prince Spaghetti Day. Oh, it isn't at the top. They moved it, Robin? I don't know. It's too much for me. It's too much. Yeah, he's smart. The failure to produce this specific information requested herein results in a violation of the defendant's rights established by the 6th and 14th Amendments to the Federal Constitution, Article 12 of the Massachusetts Declaration of Rights, establishing the defendant's rights to effective assistance of counsel, due process, and a fair trial. Massachusetts Rule of Criminal Procedure 14, the rules of professional conduct concerning the duties and obligations of the prosecutor and the common law. You remember that commercial? Anthony, it's Prince Spaghetti Day. XOXO. Brian Walsh's attorney, Larry Tipton. Deb remembers it too. Anthony. That was served on them or filed September 24th. Followed by the affidavit in support of defendant's motion for production of information concerning district attorney and law enforcement. Thank you, Lily Rose. What a disgrace. This case is so compromised because of Proctor. And thank you to Joyce for becoming a new member. Welcome. Welcome. I'm just looking at what Danny B is saying about the police audit. I don't know enough about the police audit to even opine on that, Danny. So I really can't. It's Wednesday, Anthony. Prince Spaghetti. It was Wednesday? Thank you. Hi, Larry. See, do you like all of our Gen X references? We are Gen X. We had some millennials in the chat the other day. That was exciting. No, they said it was Wednesday, though, Tony. Was it Wednesday? Donald says it's crazy that because of Proctor mistakes, he's actually going to get someone who killed his wife off. Well, if Guarino was the guy who did the forensic extraction, You might be right. I don't know. This is a no body murder case. Anna Walsh has never been found. Boomers are great. We love boomers here. So no worries. But also remember who's ruling on these motions, my friend, my friends, because there's more than one of you here. 2,030 and 32 of you here, and only 881 likes. Oh, come on, that is so lame, you guys. I'm gonna turn off the air conditioning until you hit the like button. And I'm also just going to tell you that it is Judge Beverly Canone who's going to be ruling on these motions as such. And you know how those go. Remember all the rulings in the Karen Reed case? No, her body's never been found. They believe that he hacked her up with a hacksaw. And his Google searches are what is going to allegedly convict him. We went over that in the first stream. You got to go back and watch it. The things he was looking for, searching for on his son's iPad. What's the best way to disintegrate a body if you really have to? He's also on video, I think, going to Home Goods and buying 3 rugs. That's why that rug case was so interesting to me today. The earlier one that they covered, the girl found a rug rolled up in her backyard and started digging. Then the police came with the cadaver dogs, the whole thing. But he bought rugs. So Judge Bev is going to be the one ruling on these motions. So there's that. Although when we watched this hearing, she was so nice to Brian Walsh, even so nice. And then we saw her. We happened to catch her after Aiden Carney's hearing. She came on the bench, and I'm like, hold on, we got to watch this next hearing. It was for Ingolf Turk, the doctor who allegedly killed his wife. And she was so nice to Kevin Reddington, his attorney. So she's the one ruling on these motions. Keep that in mind. I don't know. I thought she was transferred to civil court. It seems to me like these cases get transferred around to whoever's on the bench that day. I don't know, because we saw when we watched Aiden's hearing, one of my kids is like, I know you're live. I'm sorry, but I really, really need your attention right now. I really, really need you to answer this question. No, I lost my train of thought. What was I saying, chat? What was I saying? Early onset, absolute Heimers. She was really nice. Oh, Judge Katie Rayburn was on the bench, I think, for Aiden's last hearing. And I think that there had been also a Judge Krupp who sat in on that case one time. So they keep sort of moving around. It's like, is she assigning herself now to the Brian Walsh case to do Proctor cleanup? Because they just referenced an order from Judge Krupp. Or is Judge Krupp in district court, and now that this is in superior court, it's different? I don't know. I'm just, again, brainstorming with you. Here's Larry Tipton's affidavit in support. I, along with Kelly Porges, represent Mr. Brian Walsh in this matter, charging him with murder. Mr. Walsh's motion does not allege the Norfolk County District Attorney's Office of any wrongdoing. The motion addresses what has been revealed as serious questions about the conduct, decisions, and bias in its investigations, the bias and inadequate supervision of the state police assigned to the office, and other police departments reporting to the office of its investigations, and is an effort to require production of any exculpatory evidence that raises questions about the investigation of Mr. Walsh. Hello, Tom Gillis, golf instruction. Did I tell you that I got a hole in one once? I say that every time you come on. And it's true. I really did get a hole in one with a witness. And I have a plaque in the clubhouse. It's real. It's real. Don't hate me. The request for the information set forth in the motion is biased, at least in part, on the factual record now firmly established that the relationship between the state police and the district attorney for Norfolk County, DA, is flawed, problematic, and results in a lack of integrity, bias in investigative decisions, conclusions, and opinions. And really, he's trying to be nice about it. He's trying to be nice about it, but he's like, yeah, we're not alleging you of any wrongdoing. We're just concerned about, your investigators and their, bias and problematic investigatory methods. Thank you. Terry, District Court and Superior Court are separate in Barnstable County also, and judges are different in each section. Okay. Okay. The request for the information set forth in the motion is based at least in part on the factual record now firmly established that the relationship between the state police and the district attorney for Norfolk County DA is flawed, problematic, and results in a lack of integrity, bias in investigative decisions, conclusions, and opinions. Mhm. So even though Michael Proctor testified on the stand that those text messages that he sent were unprofessional and unfortunate, he actually had the audacity to say, but that did not in any way compromise the integrity of the investigation. It is clear that based on the evolving factual record regarding Trooper Michael Proctor, that there exists a lack of supervision, that biased decisions, conclusions, and opinions are allowed to flourish. You go. And that these biases infect the myriad of decisions made during the investigation and prosecutions handled by these law enforcement personnel and the DA. Well, I wonder what Larry Tipton has to say about Rubber Ducky Gate. This observation is not the single opinion of defense counsel, but shared by others. Yes. Oh, yes. Oh, yes. A. The Department of Justice initiated an investigation of the DA in its handling of the prosecution in the matter of Commonwealth v. Reed. There appears to be either a similar investigation or, at the very least, concerns for the lack of sufficient investigation into the matter involving the death of Sandra Birchmore. Mhm. Furthermore, there is a factual record evidence that Proctor was not properly supervised by his state police supervisors and was permitted to espouse biased and prejudicial comments regarding at least the defendant in the aforementioned case. And there is nothing to support a belief that other law enforcement personnel purportedly supervised by state police and reporting to the DA received adequate supervision. My experience as defense counsel indicates that the Proctor's supervisor, Detective Lieutenant Tully, has either knowingly or mistakenly represented facts in the recent case of Commonwealth v. Lopez, misrepresentations that were litigated by way of extensive pleadings. And in those instances, Tully had to admit his mistakes made in reports and sworn testimony to the grand jury and at the first trial of the matter, but only after confronted with defense pleadings demanding the truth. Okay, who knows about Commonwealth v. Lopez? Lopes. Call me Alice, because I'm going to have to go down the rabbit hole in this one. Apparently, Commonwealth v. Lopez was a problem for Tully. And here is what happened in Commonwealth v. Lopez. This is what they are asserting that Tully did in Commonwealth v. Lopez. Misrepresenting to the grand jury that a certain oh wait, I was just distracted by this. YouTube has the Wednesday as Prince Spaghetti Day commercial. We gotta eat. We all gotta eat. Oh, thanks, Pilgrim Shadow. I can't play it though, because they strike. They strike. I got stricken on my hurricane coverage for playing a news piece about people that were making meals for the displaced in Western North Carolina. So be careful what I play now. But thank you for that. Here's what Tully allegedly did in that case. Misrepresenting to the grand jury that certain critical messages were in fact read by the defendant, that if not corrected, were to be used to establish the defendant's mental state and motive. 2, misrepresenting GPS location data that, if not corrected, would have been used to suggest the defendant's whereabouts at critical times immediately preceding the incident, and notes ordered produced by way of motion that revealed that Tully's investigation reports submitted in the case did not include important details of the observations of the defendant's mental states by a critical witness at critical times immediately preceding the incident. Okay, those are all big problems. Those all have to do with GPS location data, text messages, and reporting involving Tully, who's also involved in the Karen Reed case. When was the Lopez investigation done? Does anybody know? Let me scan the chat and see if anybody knows. Manny Lopez? I don't know. Do you guys know? Wait, did that have to do with Officer Chesna? Was that the Chesna trial? They were calling it the Chesna trial, but was Manny Lopez the defendant? And didn't that result in 2 mistrials in front, or hung juries in front of Judge Cannoni also? And isn't Tully involved in Aiden's case too? Yep. Wasn't Lindsay, it's Lopes. Wasn't Lindsay texting Tully and Mello from the bathroom? Bingo. It's Lopes. Somebody's saying it's Manny. Well, you can never tell. Emmanuel Lopez? Emmanuel. Okay, look under Emmanuel. And it was Bev. She's going for the all-time mistrial record. Says none of your business. Oh, this is getting juicy. Have you guys read these papers before? Because I haven't. This is a cold read I'm doing with you right now. This is a cold read. Thank you, Grant's pants. Ugh, I can't even look at your picture. I get profile picture. Just gives me heebie-jeebies. But when exposing a crime is treated as a crime, you are being ruled by criminals. Look, you just made my eye twitch. Change that profile picture quick. OMG. OMG needs to throw in misrepresentation of Google data. Well, there was some, misrepresent. Hopefully, Karen Reed's defense can use this in her retrial. Another example is a report submitted by other state police investigators in that case, that same case, Lopez, that were intended to support an argument that the defendant mocked the police on social media, were eventually shown to be unreliable. And upon motion by the defendant, were eventually not used by the Commonwealth. Wait, were they faking social media posts by the defendant? Did anybody follow that Chesna trial? Did they fake social media posts by him mocking the police? Runs deep. This is not Reddington. No, his name is Larry Tipton, the defense attorney for Brian Walshe. Wow. At least one legal scholar has been quoted in the Boston Globe article regarding the emerging facts of the Birchmore investigation and the Proctor matter that, quote, the entire infrastructure is built so that prosecutors are able to protect officers who are their star witnesses, said Nicole Gonzalez Van Cleve, a Brown University associate professor of sociology who co-authored a 2020 report on the relationship between police and prosecutors. It is clear that in the Proctor debacle, oh, he's just calling it the Proctor debacle. I think I might have to adopt that. Proctor debacle. And based on experience of defense counsel, the biases and detrimental impact of such biases and flawed relationships appear historically to only be forthcoming when defense counsel, as was the case in the Commonwealth v. Reed and in Commonwealth v. Lopez, bring a court's attention to what is believed to be exculpatory evidence of the professional negligence that otherwise would have remained hidden from view. And now you're going to have to remind me of all the stuff that Judge Canone did not allow into the Karen Reed trial. Because we did all the motions in lemonade, as the closed captions called them. This observation is further supported by evolving case law cited in the attached memorandum of law and fact. It is for these reasons we seek, on behalf of Mr. Walsh, the Commonwealth be required to inquire and disclose, and to do so consistent with the prevailing law of discovery. These requests are grounded in the belief that only due diligence and a review of the materials by experienced defense counsel well-versed in the relevant allegations of this case and information derived from its own ongoing investigation can determine whether inherent bias, professional negligence, or a casual disregard for justice has permeated the investigation of Mr. Walsh. True can't be no. Or Mike can go to medical school to become Dr. Proctor. Proctorologist. Can be a proctorologist. I just made that up. We're riffing. He goes on to say in paragraph 11, in my opinion, it would be ineffective assistance of counsel to not make the requests in this motion and to ignore the revelations summarily described above and to rely on what appears to be a failure of the DA's office to properly supervise its investigating agents and the failure for those very agents to properly supervise themselves. Ooh, those fighting words. Self-supervision, is a really important skill. They don't seem to be able to get it. What's more, Proctor, as quote, case officer, I see what he did there. Of the investigation of Mr. Walsh, as well as other state police assigned to the DA's office, were in charge of and intricately involved in the investigation of Mr. Walsh, resulting in the indictment charging him with murder. In this case, until he was suspended, Proctor was considered the lead or primary investigator, was involved in interviewing critical witnesses, was present for a majority of the grand jury presentations, reviewed other investigator reports and forensic reports, presumably interviewed and prepared grand jury witnesses, reviewed and supervised other agents of the Commonwealth, put supervised in quotes, helped in the drafting of reports, determined what leads to follow and not follow, made a decision or was instrumental in making a decision to target Mr. Walsh, and in summary, shaped the scope of the investigation leading to the indictment. Wouldn't it be wild if Proctor had notes? If he took notes for this investigation, which was almost exactly 1 year after the murder investigation of Officer Joneke, wouldn't it be wild if he had notes in this investigation? And all of a sudden, they just appeared. They just revealed themselves. Lopez is the Chesna trial. Thank you, Lebaners. That's what we were saying. Case officer in quotes. Jennifer Duncan. If it looks like a duck. I love seeing everything for the first time with you. This is so good because it's like a real reaction. Yep. Thank you, Mrs. Jim Morrison. Shut up. Bev told her she couldn't cry. Yes. She was not allowed to show any emotion in the courtroom. I do remember hearing about that. She was a battered and now deceased wife. Yes. Delene says, so was Trooper Guarino sitting out on the side of the highway saying, kill me, when he was sitting out on the highway when he was hit by the OUI driver? Have they released that information that it was really him yet? I don't know. Importantly, the investigation of Mr. Walsh was being conducted at or around the same time that Proctor, his supervisors, and other agents of the Commonwealth were investigating the aforementioned Reed case and making biased and unprofessional remarks and decisions. Well, let's see. Were they still investigating John O'Keefe's case in January 2023? I think they were, right? Because they still had not even turned over a whole bunch of stuff. 15, the Proctor debacle resulted in Proctor being first suspended and then terminated from the state police. That's the typo, allegedly. Allegedly, this is not true, that he's been terminated, because we just read an article from the Boston Herald, if you believe mainstream media. But only after defense counsel exposed the serious issue. Defense counsel meaning Karen Reed's defense counsel. It is now clear that the Commonwealth has also determined not to call Proctor as a witness in the Walshe case. This decision speaks volumes about the impact Proctor's conduct has had on its investigation and lends substantial support for production of the information sought in this motion. The media reported that the parties in the Reed case and the Commonwealth have been provided notice of its receipt of 3,074 pages of records specific to the investigation of the death of Officer John O'Keefe. Additionally, on September 6, 2024, the Commonwealth notified the parties of its receipt of digital data regarding Proctor, that it has initiated its own review of that data, and that it is considering having someone purportedly independent, I love how he says purportedly independent, to review those records, presumably for exculpatory information. A suggestion that someone independent of the DA's office is qualified to review documents in this manner under these attendant circumstances ignores the SJC's reasoning, logic, and decision to change the framework for evaluating statutorily privileged records in Commonwealth v. Dwyer, as discussed in the accompanying memorandum. Doing away with in-camera review, establishing a review process whereby defense counsel, with protections in place to ensure there is no disclosure of privileged information, review the privileged materials. Okay, well, if he's accurate about what that case says, then it's like, yeah, no, you give us everything. If Commonwealth v. Dwyer says that, you give us everything, and we will look at it, and we will make sure that nothing that is privileged or that doesn't have to do with our case is revealed. You don't get to just do it yourself or call in your own independent team. That's not what this case says. It says you got to give it to us, and then we will protect whatever is not germane or whatever's privileged. Okay, interesting. I'm going to have to look that up. This is referencing all of this. What is it? Is it referencing? This is referencing Karen's case, but the case that we are reading right now, this is Brian Walsh's counsel's discovery demands of the Commonwealth in the Brian Walsh case, if you just tuned in. It is not an overstatement to simply state that defense counsel, knowing the allegations, relevant facts, circumstances, possible defenses, and information not in the possession of the Commonwealth, based on the defense investigation, is in a better position to determine what is potentially exculpatory evidence buried in the information requested. Importantly, the requested documents are not privileged by statute, and even where there is heightened concern that sensitive information not be revealed, protective orders have long been used by the courts to guard against such disclosure. The bias and resulting damage may be intentional. It appears to be, in many instances, in one, the Proctor matter, two, in failing to include relevant and exculpatory information in final reports as described above, and three, in the DA's office presumably being unaware of the Proctor's negligence, the Proctor, the Proctor, and bias, and when made aware of the same, sought to diminish it and its impact on the prosecution in the Reed matter. Oh, yes, they did. Oh, yes, oh, yes, oh, yes, oh, yes. Remember the pretrial motion about dismissing the indictment because of all the BS that happened in front of the grand jury? About Proctor coming in there and testifying, minimizing his relationship with the Alberts, and how the defense in the Reed case argued he lied about that in the grand jury, and all of it was brought out, in addition to so many other things that were allowed into the grand jury. The totality of things, in my opinion, may have reached the level, but Judge Cannoni said no, doesn't reach the level. And yes, the DA sought to diminish it and its impact on the prosecution in the Reed matter. It's absolutely 100% true. Apparently, that has now changed over time, with Proctor being suspended and the Commonwealth belatedly determining that they will not call him as a future witness in any case. And it is critical to consider implicit bias and the resulting need for these requests in this case. Bias does not have to be intentional to result in damage and a biased investigation. The SJC has approved and recommended a preliminary and final instruction on implicit bias. This court should not ignore the implications of implicit bias as it pertains to law enforcement decisions made in the investigation of Mr. Walsh and other cases. For example, jurors are instructed in part to not rely on personal and unsupported assumptions you may have, and to do your best to resolve this case based upon the evidence and law without sympathy, bias, or prejudice to the best of your ability as human beings. While the same admonition should be applied by the DA's office and its agents, apparently it does not in all occasions. I think Larry Tipton might be one of my new favorite defense attorneys in the Norfolk County area. Just put him on the list. We got David Unetti, we got Alan Jackson's LA, but we're counting David Unetti, Alan Jackson, we got Larry Tipton, we got Bradel, we got Betterow. We're making quite the list here. There is literature to support the effects of implicit bias on professionals such as police officers and prosecutors. In conclusion, the requested discovery should be produced, based in part or in whole on the established facts of Proctor's conduct, leading to his suspension, and now the Commonwealth's decision to not call him as a witness, and the other reasons stated in the defendant's motion, including but not limited to the association between the DA's office and Proctor and the state police, wherein the state police officers are specifically assigned to and provide investigation services to the DA's office in the investigation of alleged crimes, the investigation of the DA's office by the Department of Justice, and the Boston office of the U.S. Attorney in the emerging information regarding the flawed investigation of the death of Sandra Birchmore. XOXO, Larry Tipton, September 24th, 2024. Let's break for a second and look at the chat before we go to this memorandum of law. The Tipton Papers. Yes, the Tipton Papers. We've named them. The Tipton Papers. Deb Vitt is like, are you kidding me? Nope, not kidding you. Thank you to Joyce for becoming a new member. Welcome. People are talking about perjury. Grace Bay says Proctor's argument on the stand was that he was intentionally biased, but it didn't cause any problems. I think, I don't know if, I think he said it was unprofessional and unfortunate, but did not compromise the integrity of the investigation. I don't know that he said he was intentionally biased. I don't recall that. So there's that. The Tipton Papers and the Betterow letters, all in the past 2 weeks. We're here for it. Tipton was court appointed, yeah? In Walsh? Wow. He's a public defender? I didn't know. Oh, yeah, I guess, because I don't think that Brian Walsh has any money left because he was selling those fake Andy Warhols on eBay and he got caught. And then he was sentenced, or he was in the process of being sentenced when this happened. And he was also Googling things like, how long does a person need to be dead before you can collect insurance? Allegedly, because, according to Guarino, Google searches aren't accurate. Because when you open a browser, it reverts back to like the last thing you searched or some crap like that, right? Beth says the first jury in the Chesna case was Buston from Worcester. Second jury was picked from Bristol County, per Cannoni. So they picked a jury in Worcester and they came and tried it in Norfolk. And that case resulted in a mistrial 2 times. Is that true? Haas longed to be dead. Is Richard Johnson right? Haas longed to be dead before I can collect on my wife's insurance. Proctor said he was emotional, said Adam Lalley's resignation. So emotional. There's a trivia night fundraiser tonight and they're live streaming it. Oh, that's fun. I'm sure it'll be done by then. Thank you, Little Miss Red Velvet, for your compliment. I appreciate you so. Everyone, please hit the like button to push the video out. Yes, it's a public defender. Walsh is out of money. Well, guess what? He's getting the taxpayers' money's worth with these papers. He's doing right by him. He also stole from his parents. Yep, I remember that. Good citizen. Walsh is a checkered past, to say the least. Okay. Let me just check the page count on this. I'm going to get off for 1 second. Just don't worry. I'm going to be right back. Ooh, all right. So this memo is like another 21 pages. I don't know that we need to really read the whole thing, right? Do we? We've already been here for an hour and 15. We were here all morning watching The Dig. You tell me if you want to read it. We can skim through it and read the pertinent portions if you like. So basically what this is just a bunch of case law setting forth all the reasons for everything that we just read should be granted by the judge. And I don't know, I can't read that fast. I can't read that fast. Here's the memorandum. We'll hit the highlights, mommy. All right. Thank you. No, we didn't have 2 mistrials. Walsh has not been tried yet. Walsh is awaiting trial. Walsh is in discovery. They want everything from Proctor's phone because of what happened in Karen Reed and what happened in Sandra Birchmore and what happened apparently in this Manny Lopez case that had to do with Officer Chesna's death that resulted in 2 mistrials. Okay. Walsh's attorneys want all of the stuff regarding Proctor, as do Turk's attorneys, Kevin Reddington, Dr. Turk, Ingolf Turk, coincidentally also being handled by Judge Cannoni so far, involves Proctor. Just I'm going to look up on mass courts and see when this Walsh case is allegedly supposed to be tried. Just give me 1 second here. I do know that there's another hearing. Really? Come on. This is what, sometimes they do this. You need the case number. It's like a whole thing. Two, three, 8, 2, 2, 3. Oops. Anybody else have that problem where sometimes you just can't get it to come up under the name? Right, but then it comes right up. Oh, because his name is Brian Reza Walsh? Come on now. Oh, yes. Oh, yes. Oh, yes. Oh, yes. All right, so there's going to be a motion hearing on December 2nd in front of at 2 p.m. in front of Judge Beverly Canone. So we'll be back to cover that. So that's when this motion is going to be heard. But it doesn't have anything regarding a trial date, expected trial date, or anything like that. Anybody know if they've ever spoken about it? I'm not sure. Could be another year from now. Who knows? And Massachusetts does not make it easy to get court documents as easy as some other places do. All right, so December 2nd, we'll have to come back for another hearing. Okay. Thank you, Susie Q. Boston. One mistrial with Chesna, then Lopez got life with the possibility of parole. Oh, so he got a better sentence than Carly Gregg, who got life without the possibility of parole, and Chesna killed a cop? Okay, gotcha. He does have multiple names. Yeah, sometimes I think you have to put the middle name in. And that's the deer. Oh, and look, they're only spelling Walsh with one without an E on this. It has an E. Here's the memorandum in support. We will skim through here and read any pertinent portions. Defendant Mr. Brian Walsh has filed a motion seeking discovery of documents, digital data, records, and materials concerning the Department of Justice investigations involving the Norfolk County DA's office and its handling of an investigation involving the allegations of murder, documents, and digital data regarding Proctor, a state police officer, and agents of the Commonwealth involved in the investigation of Mr. Walsh. In January of 2023, Trooper Michael Proctor was designated as the case officer. Case officer just cracks me up every time I hear it. In the missing person and murder investigation of Anna Walsh by the Massachusetts State Police. I'm going to put my email up here. And if anybody has the original like police reports on Walsh, the probable cause affidavit, anything like that, if you would email that to me, I will completely give you a shout out unless you want to remain anonymous, which if you do, I completely understand. And I'll put that up here. If I can find the banner that I already made. Here it is. Okay. It's fanbase at mlittlelaw.com. If anybody has the original MSP reports so that we can go over them together, I'd be very interested to see that stuff as we continue into our deep dive. We showed some video the other day. If you didn't watch that stream, go back and watch it later. Well, he was designated the case officer in the missing person and murder investigation of Anna Walsh by the MSP. The Commonwealth has announced it will not call Proctor at the time of trial of Mr. Walsh. The fact Proctor was, quote, case officer in Mr. Walsh's case and the disclosure that the DA's office has now chosen to not use him as a witness are two important factors reinforcing rather than distracting the need for production of the requests made in Mr. Walsh's motion. Footnote 1. The effects of Proctor's bias, his lack of supervision, and the complacency of his supervisors on the investigation of Mr. Walsh do not disappear and become irrelevant because the Commonwealth chooses to strike Proctor from witness lists. Go La. We're just going to call him La from now on. I have a friend named Larry, and we call him La. The requests are made pursuant to Rule 14, Mr. Walsh's rights, state and federal constitution. They need to provide us with exculpatory evidence. And we don't need to repeat them here. Serious issues raised in various pleadings, trial testimony, and media that raise substantial questions about the integrity of the DA's ability to properly investigate serious crimes and the state police and law enforcement in the investigation of criminal cases in Norfolk County, many of whom are assigned to the DA's office. Yeah, that's another very strange thing about Massachusetts is that they have specific troopers assigned to DAs, which is something we don't see in New York. I don't know where y'all where y'all are from, but we don't have that in New York. We have the NYPD and they work for the entirety of New York City. They're not assigned specifically to a county DA's office. So it's kind of weird. And we have state troopers, but they're also not assigned to a specific DA's office. And if I'm wrong about that, law enforcement, New York law enforcement in the chat are retired, tell me, but I don't think I am. Bettero and I talked about it one night. Footnote 2 says the relationship between the state police unit assigned the DA's office raises serious questions regarding this motion. Media reports and legal scholars has commented on this issue. And then this is a quote. But critics question why outside investigators weren't brought into the case from the onset, particularly after detectives determined Birchmore was pregnant and claiming Farwell was the father. Academic experts and local advocates argue that prosecutors and police officers have tight professional relationships that can taint the integrity of their investigations. Next quote, the entire infrastructure is built so that prosecutors are able to protect officers who are their star witnesses, said Nicole Gonzalez Van Cleve, a Brown University associate professor of sociology who co-authored a 2020 report on the relationship between police and prosecutors. Then they link the receipt. More specifically, Mr. Walsh's requests are based on the factual record established that 1, Proctor demonstrated bias against a person accused of murder, Karen Reed. 2, Proctor was not properly supervised, shown by the text messages during trial where his fellow officers liked his messages when he was looking for nudes and, liked his messages about, trying to get the Emmy on board with changing her manner of death from undetermined to homicide and such things like that. 3, the relationship between the DA's office and the state police creates a problematic relationship that prevents proper supervision of its investigators. 4, there is reason to believe the DOJ has concerns about the DA's office and how it handles investigations. Well, yeah, considering they're involved in not only Sandra Birchmore, which finally led to the arrest of alleged murderer Matthew Farwell 3.5 years after the MSP and Canton PD ruled it a suicide, and also are dipping their toe into the waters of the Karen Reed investigation. No arrests have been made yet, but remember also that Sandra Birchmore's case occurred in February of 2021. These are all like immediately in a row, in succession, in quick succession, exactly almost 1 year of each other. Sandra Birchmore was found beginning of February 2021. Officer John O'Keefe, January 29, 2022. Anna Walsh goes missing New Year's Day, 2023. They're spilling all the tea in this. And 5, revelations emerging concerning the Sandra Birchmore failed investigation at a minimum suggest a biased approach to investigating wrongdoing by law enforcement personnel. This is a mess. This is a mess for the Norfolk DA's office. Not to mention all the people that are currently sitting incarcerated, like knock, knock, knock. Proctor was my customer service rep too. Guarino's the guy who had me convicted based on his interpretation of my cell phone data and the Celebrite reports. It's a problem. I'm going to take this down now because if anybody does have those MSP reports on Walsh, I'd love to see them. Not right now, at your leisure. Thank you. Given the above, the basis for Mr. Walsh's request can be equated to the 3 concerns outlined by the SJC in a recent case where the SJC specifically held the following. Okay, good. I don't have to read the case because he's going to quote it for us. First, the practice of the District Attorney's Office of disclosing adverse credibility findings made about the Springfield Police Department's officers' witnesses only on a discretionary basis violates the duty of the District Attorney's Office to disclose. Second, the practice of the District Attorney's Office of withholding instances of officer misconduct from disclosure where a particular bad act cannot be attributed clearly to a particular officer violates the duty of the District Attorney's Office to disclose. Third, by failing to gain access to all documents known to have been reviewed by the DOJ, the district attorney's office failed in its duty to investigate. Okay, and that is quoting a 2024 case, Graham versus District Attorney for Hampton District, which is a different district attorney's office, but it's Massachusetts case law. The requests herein are an attempt to ensure the Norfolk DA does not ignore or simply misinterpret and possibly gloss over on a discretionary basis what is exculpatory information contained in the record sought. The defendant's motion requests certain categories of documents and information. One concern is that the DA's office, given the volume of materials, may choose not to review the contents of all such documents under the mistaken belief that a category of documents is not relevant or is simply ill-equipped to determine what is truly exculpatory in this context. But those beliefs would result in a violation of Mr. Walsh's rights and would be contrary to the law. In any event, at a minimum, the DA would still need to produce all documents in the requested categories to permit counsel for Mr. Walsh to search for exculpatory information. Yeah, he's right. He's right. See the discussion in Graham, which is that same case from before, that the SJC held that to the extent that these materials are not internal affairs records, the district attorney's office must obtain all documents falling into these categories from the department in order to fulfill the duty of the district attorney's office of investigation. Furthermore, the obligation here extends to any additional or new exculpatory information that arises in the exercise of fulfilling its obligations. Defense counsel's obligation. The SJC and Graham addressed the importance attached to the production of exculpatory information and re-emphasized the importance of a prosecutor's dual duties to disclose and to investigate in upholding the integrity of our criminal justice system, and stated it is the responsibility of prosecutors and defense attorneys alike to ensure that the due process rights of every criminal defendant are vindicated and protected. Exculpatory, and then it says here, footnote 3, let's see. The defendant herein relies in part to the SJC's logic and reasoning decision in Graham. We understand the underlying substantive issues in Graham involving a pattern and practice of the Springfield Police Department in violating defendants' rights over a period of years, and the Hampton DA's neglect in adhering to the law with regard to disclosing exculpatory information. But the SJC's discussion of the relevant law applicable to Mr. Walsh's request changed nothing in that regard except one thing, and clearly reinforced the critical need to ensure a DA's obligations are honored. The SJC made it clear that the prosecution's obligations at issue must be and will be enforced, or there will be consequences in any failure to do so. While the relative law in this area was not altered in Graham, what was required to change was a DA's office choosing to ignore the rights of defendant that had gone on for years. This motion is one effort to ensure this does not happen in Norfolk County, given the present circumstances and investigations underlying Mr. Walsh's motion. Wow. If you guys are telling me that he's a public defender, I'm blown away by this incredible piece of legal literature and argument. Exculpatory evidence requested only needs to diminish Mr. Walsh's culpability to mandate production. It is well established that the due process of clauses of the federal Constitution and the Massachusetts Declaration of Rights require that the Commonwealth disclose to a defendant material exculpatory evidence in its possession or control. Exculpatory evidence in this context is not evidence of innocence. To be considered exculpatory in the context of production of discovery, as requested in Mr. Walsh's motion, evidence need only tend to diminish a defendant's culpability. I'm going to break to just remind you that if you did watch the Alec Baldwin trial, Special District Attorney Carrie Morrissey took it upon herself to not turn over some information in the Alec Baldwin case because she determined it to not be relevant. In fact, it was such a mishigas that she put herself on the stand during the Alec Baldwin trial to try and get herself out of some hot water about why she didn't turn over this potentially exculpatory evidence. And immediately, the New Mexico judge dismissed the charges against Alec Baldwin. That's how heinous this type of conduct is. Okay? Thank you. Thank you, Team Brittany, for that. Mama She, thank you so very much for your very generous Cash App, not only today, but yesterday. Mama She is in here for a hunch. Thank you. You're amazing and such an amazing supporter of this channel. And I can't even really thank you enough. Thank you. Okay. So that's what happened in Alec Baldwin. Immediately, that judge, I forget her name right now, dismissed the charges against Alec Baldwin. Bye-bye. You're gone, sir. You're free to go. That's how heinous a Brady violation is. This is. You don't get to decide as the district attorney what's relevant, what's not, what's exculpatory, what's not. You got to turn everything over. That's the law. That's what Brady stands for. It's a problem. Carrie Morrissey's still digging that hole, huh? Judge Summers, is that who that was? She was great. There are a lot of judges I would like to transport to Norfolk County. And so again, it's kind of probably going to get repetitive, but the DA's obligation in this context is not discretionary, like we just talked about in Carrie Morrissey, Alec Baldwin. Article 12 guarantees every criminal defendant shall have a right to produce all proofs that may be favorable to him. Going back up here, they also cite Brady. Admissibility is not a determining factor in determining the scope of the DA's obligation to investigate and disclose under state and federal law. See Brady v. Maryland. Rather, it is the nature of the information, turning only on whether the information has a tendency towards exculpating a defendant, citing matter of grand jury investigation. The obligation to disclose exculpatory material is an obligation, not a decision. And the DA's office must disclose exculpatory information. And in where such disclosure is required, a failure to do so is akin to active concealment. Well, that's what the New Mexico judge thought too. Mr. Walsh, I'm skipping around, so just, I'm not reading every single word because, we'll be here all night. Mr. Walsh should, in the ordinary course, not have to press for disclosure of exculpatory information, as he does in his motion. But the underlying concern here is that, given the present circumstances, there is a serious question about the DA's ability to seek out exculpatory evidence in the information requested. Right. He's basically saying, Judge, you should not trust them because look what had happened. And here's what happened in 2020 in the Springfield Police Departments. The U.S. Department of Justice conducted an investigation of the Springfield Police Department in 2020. Oh, that's, wow. Did you guys know that? And the DOJ found that the department's officers, particularly those within the Narcotics Bureau, routinely falsified police reports and engaged in a pattern or practice of excessive force. These findings raise questions about the integrity of the evidence used by the Office of the District Attorney for the Hampton District Attorney's Office to obtain convictions. We are called on to determine whether the District Attorney's Office failed to comply with his obligations to disclose and investigate evidence of the department's misconduct. And let's just break from this to say it has been over 3 weeks since the unattended death of Enrique Delgado Garcia at the Massachusetts State Police Training Academy, and we still have no answers about whether he suffered a medical event or was beaten to death in a boxing ring in a training exercise. So there's that. Then they go on to talk about constitutional rights and the duty of the DA in other cases. And it even goes further than that. The obligation extends in some cases beyond a specific case under investigation and is applicable to any criminal case in which that officer prepared a report or may serve as a witness. So they're saying, they want to get a taint team and they want to dig through Proctor's phone and cloud records and they want to determine what's relevant to the Walshe case, well, guess what? In this case, Graham, they're going to have to turn over stuff in other cases too. So just give everything to us. And we, as officers of the court and attorneys, will protect it accordingly. These cases have also established that this information requested includes not just the law enforcement officers involved in the case, but also the state police crime lab chemists, victim and witness advocates, and medical examiners, and the internal affairs records. Mr. Walsh's request, this is with regard to the internal affairs records of Proctor. Mr. Walsh's requests do not raise an issue of conflicting procedural guardrails for disclosing exculpatory information. Mr. Walsh's requests are made with an understanding that the DA's obligations to disclose certain categories of information have different procedural requirements for disclosure. The defendant acknowledges that his obligations with regard to internal affairs records not in the possession of the Commonwealth or its agents may be different and subject to the discovery procedures laid out in these other cases. Setting aside the different obligations applicable to disclosing information about civil cases, criminal investigation, and internal affairs reports, this motion simply requests information in the possession and control of the DA's office and its agents. The underlying concerns for Mr. Walsh's requests are in part evident from the many failures that have been revealed in the Commonwealth v. Reed prosecution or persecution. Now the serious issues just emerging in the Sandra Birchmore investigation. And then they go on a little bit to talk about that. And while Mr. Walsh acknowledges the differing obligations, it is clear that Proctor, as well as other state police involved in the investigation of Mr. Walsh, are part of the internal state police unit assigned to the DA's office. It would seem a contradiction in logic and reasoning to simply say the DA's office in these circumstances can turn a blind eye to what it knows about its own investigators. Any argument that disclosure of what is known and what the DA or its agents possess requires the Juanes-Rodriguez procedural framework to be applied. Contravenes applicable law. This is made clear in the discussion of these reports in Graham. The quote is, even while shielding internal affairs records from automatic disclosure, this court provided criminal defendants with avenues to access any salient information contained within internal affairs files. If a prosecutor actually possesses police department internal affairs records, the prosecutor must review that material in response to a Rule 14 motion. If a prosecutor does not possess such records, a defendant may obtain statements of percipient witnesses contained within an internal affairs file via a motion under Rule 17 as appearing in this case. Okay. Thanks, Susie Q. Boston, for your super sticker. Appreciate you. I'm going to scroll through this slowly so you can come back and read it if you like. Defense counsel must be able to review the information in the first instance, give it all to us, because it used to be almost 20 years ago, the SJC determined the procedure by which statutorily privileged and confidential information was first reviewed in camera by the trial court judge was flawed. So 20 years ago, it used to be that you would give all this information to the judge would review all the stuff, and then the judge would say, here's what you got to turn over. But in this case called Dwyer, they changed the procedure, and Dwyer is quoted as saying, experience has also confirmed that trial judges cannot effectively assume the role of advocate when examining records. Requiring judges to take on the perspective of an advocate is contrary to the judge's proper role as a neutral arbiter. Despite their best intentions and dedication, trial judges examining records before a trial lack complete information about the facts of a case or a defense to an indictment and are all too often unable to recognize the significance or insignificance of a particular document to a defense. Yeah, remember that time? Remember that time all the way back when, in a pretrial hearing, Judge Bev said something like, "Who is this Higgins anyway? Is Higgins even have anything to do with this case?" I think it was Higgins, right? So it seems that they since then changed the standard to say what? That we should be able to get it. Over 450 years ago, even that was decided 20 years ago. 450 years ago, a phrase was first uttered applicable to the need for defense counsel. I love when they start quoting things from 450 years ago. A phrase was first uttered applicable to the need for defense counsel to review the documents and not leave it to the DA's office or some other entity amounting to the fox guarding the henhouse. Either possibility is woefully adequate, woefully inadequate. I mean, we got to read the footnote on that, right? The phrase reportedly originated in the 1580s and is used often over 450 years later. Here it is from 1589. He is a wolf to keep the sheep and a fox to look to the hennies. Wow. Didn't we know fox guarding the henhouse is a 450-year-old expression? I had no idea. Procedural rules were promulgated in Dwyer whereby defense counsel reviewed and only defense counsel may initially review the privileged and confidential information under the strict adherence with the protective order. Okay, just give it to him. Who's guarding the fox? Yeah, none of your business. Next argument, ambiguity or confusion. Defense counsel is in the best position to evaluate the requested information and to determine its exculpatory significance and ultimately whether to assert its admissibility at trial following a hearing. Yep, agree, agree, agree. Look at see Baldwin. See New Mexico versus Baldwin. They don't say that, but I would. And here we can issue a protective order or we can keep things, Judge, we know how to do this. We can do this. We can do it. We can do it. Concerns expressed by the DA's office in its notice entitled Commonwealth's Notice Regarding State Trooper Michael Proctor's work phone data, dated September 6, 2024, which we looked at the top of the stream, disclosing its possession of Proctor's data, cites its concerns for the need to maintain the confidentiality of some of the information in its possession. The notice also cites, in footnote 1, a plethora of statutes and case law, suggesting the DA's office is bound by such statutes and case law to not disclose at least some of the information. And finally, the DA's notice references its intent to explore whether to send the information out to an independent entity to review the information for exculpatory information. First, the obvious question is why a so-called independent review by an as yet unknown entity preserves confidentiality and adheres to the statute cited any better than disclosing the information to Mr. Walsh's counsel under a protective order. Simply put, it does not. I'll take his word for it on that instead of reading all the case law to you. A protective order is the simple solution, not bringing in another entity to do what that entity is incapable of doing. Good point. Experience requires production of the requested information. Counsel's experience includes instances of the state police assigned to the DA's office choosing to omit or distort, and whether intentionally or not, in essence, try to conceal exculpatory evidence, maybe evidence of blatant bias, as is the case with Proctor, or implicit bias discussed below. For example, okay, here's where it's going to get good. If you haven't been listening, start listening now. For example, Detective Lieutenant Tully was reportedly the supervisor of Proctor. In a recent case, footnote 8, Commonwealth v. Lopez, it was demonstrated that Tully distorted and misrepresented facts. These misrepresentations were only revealed when brought to the attention of the trial court in extensive pleadings. As a result of the defense filing various trial motions, in an attempt to challenge Tully's omissions and distortions, the DA's office and Tully had to admit his mistakes made in reports and sworn testimony to the grand jury. These instances include, but are not limited to, the following. 1, misrepresenting to the grand jury that certain not corrected, before we read this, did anybody know that Tully was involved in the Lopez case and that he did all this stuff in the Lopez case? Was that widely published in the Norfolk County area, in the Boston Globe, in the Boston Herald? Did all this stuff come out about Tully and Lopez? I mean, you guys, didn't the Chesna trial, the second trial for Lopez, just end like right before Karen Reed's trial started? Anyone? Was this? Nope. I mean, you guys are local. You guys are boots on the ground local. No, I did not know. Is this all? Are we learning all this stuff right now? That Tully may have lied in these Chesna cases and that it was only because the defense found out and brought it up? Ooh, baby. Nope. Nope. Got some nope emojis for the chat. I mean, what other emojis can we use for this? Maybe from the Karen Reed. I mean, look, puffy jacket. Because this is getting like puffy good, puffy P. Diddy good. Was not widely publicized, huh? Put some lies. Yeah, Thompson twins in there for you. Wow. Has anybody else like covered this on YouTube? Are we just finding this out now for the first time together? Okay. Look at us. Took Larry Tipton to bring this to our attention today. Oh, Aiden did. Okay, good. Okay, good. Good. Thanks, Lisa. Good. I want to give credit where credit's due. I've never heard of it. I've never heard it before. But thank you. And Tully's also involved in Aiden's case. And everybody thought Aiden Carney was such a conspiracy theorist making stuff up, right? All right, well, let's go back to it. These instances include, but are not limited to the following. 1, misrepresenting to the grand jury that certain critical messages were in fact read by the defendant that, if not corrected, were to be used to establish the defendant's mental state and motive. 2, misrepresenting GPS location data that, if not corrected, would have been used to suggest that defendant's whereabouts at critical times immediately preceding the incident. And 3, notes ordered produced by way of motion that revealed that Tully's investigation reports submitted in the case did not include important details of the observations of defendant's mental state by a critical witness at critical times immediately preceding the incident. Another example is a report submitted by other state police investigators in that same case that were intended to support an argument that the defendant mocked the police on social media that were eventually shown to be unreliable, if not fabricated. So did they fabricate evidence against Manny Lopez? Huh. The Commonwealth eventually decided not to attempt to even use the flawed evidence after the defendant in that case filed his pleading challenging the evidence. Now I got to dive into the Lopez pleadings like an inverted video. Like other cell phone data, not as such. John O'Keefe's phone didn't go up 3 flights of stairs. That could just happen from, going over a hill. Oh, Thank you, Lisa. I met Aiden covered the story, but I'm not sure if he knew that Tully lied. It's news to me. He's the one who would know, though. Thanks. Nikki Zibs. People always talk down to conspiracy theorists until the truth slaps them in the face. Shall we call that a biatch slap? We like to keep it clean here. We try anyway. We are going down a whole new rabbit hole today that I didn't even know was coming because I didn't read this ahead of time. No, I do not think that Reed could file for a change of venue. I do not think she would or should. The prosecution, the DA wouldn't. She could, but I don't think she should because I think the people of Norfolk County, many of them, are very invested in this case, and I think they're the ones who should be the jurors in this case, or jurors, depending on where you live. We're not losing it, friends. This is happening. We are in the moment. Thank you, Auntie Bev's verdict form. Huh. Candy Cane says he shot a cop and a woman watching. I thought it was cut and dry. Moving on to implicit bias. Finally, Proctor was designated the case officer in Mr. Walsh's case. The Proctor debacle clearly demonstrated his bias towards persons accused of serious crime. His supervisors, at worst, ignored the signs of such bias, but in the least glossed over Proctor's biases and obviously did not recognize and acknowledge the taint that an investigator's bias inflicts on the integrity of the investigation. But apart and aside from an investigator's clear bias, there is another reason for Mr. Walsh making these requests, and that is implicit bias. Implicit bias. The duty imposed on defense counsel to request the information in this motion on behalf of Mr. Walsh is at least in part grounded in the understanding expressed in relevant literature that bias affects opinions and conclusions. And this bias can and does affect the DA's office, its agents, and any independent entity suggested by the September letter that may be brought into the review process. In short, bias in any form would impact any determination of what is exculpatory in thousands of pages of documents. Footnote 9. Which talks about there's no reason to acknowledge the importance of recognizing implicit bias. I'll leave that here for you in case you want to read it later, because I'm already losing my voice. With regard to the acknowledged and possibly adverse effects of implicit bias, jurors are now instructed on implicit bias at the beginning of a case and before they deliberate. Implicit bias in the investigation and prosecution of cases results in different assessments, opinions, and decisions about the scope of a DA's office to investigate and disclose, making it difficult and at times impossible to, if obligations have in fact been honored, as it was in the Graham matter, and is evidenced by the relevant jurisprudence. See Brady and its progeny. In Proctor's example, regardless of the type of bias present, such bias is evident from Proctor's willingness to disparage the accused while purporting to be objective. History demonstrates that such bias can result in countless defendants' rights being violated for years. For example, in the failings of the Hampton DA's office at issue in Graham. And it appears, as it does in this case, that the relationship between the Springfield Police Department and the Hampton DA's office was at least in part due to years of a failure to properly investigate and disclose exculpatory information. What's more, if Proctor was supervised, in quotes, by his superiors, who in turn simply turned a blind eye to his bias and casual disregard for his obligations as a state police officer, demonstrating their own bias and lack of interest in supervising its agents, and the DOJ investigation of the Norfolk DA speaks volumes about what can be characterized as the DA's own biases. And this is reinforced by the emerging revelations of the possible lack of integrity in the investigation of the Birchmore death. Neither the Proctor debacle, the questionable handling of defendants' rights in Graham, neither the Proctor debacle, the questionable handling of the tragic death of Sandra Birchmore, nor the violations of defendants' rights in Graham would have come to light but for the efforts of defense counsel in those cases. talking about Reed and Chesna. Reed and Lopez. I'm sorry. Chesna is the victim in that case, right? Conclusion. Coincidentally involving a police officer, right? As in the Karen Reed case. Conclusion. Accordingly, for the reasons set forth above, Mr. Walsh's requests for production of the information including the request to permit defense counsel to review all the requested documents, digital information, 3,074 pages of DOJ reports should be allowed pursuant to an appropriate protective order. XOXO. XOXO. You don't need a team. Give it to me. Give it to me. I am defense counsel. I know how to do this. Here's what the case law says. You don't need a taint team. You need to give it to me. Please hit the like button, folks. No wonder they want Aiden in prison. Says it looks like a duck. Isn't it the same group of law enforcement in all these trials, says Michelle Dunn? Yes, it is. You know why? Because all of these Massachusetts State Police troopers are assigned to the Norfolk County DA's office. So they do all of the investigations of what they call unattended deaths in Norfolk County. Those guys, tell them the guy never went in the house. The guys signed to the Norfolk County DA's office are all the same guys that investigate all unattended deaths in the county. Ashley Lauren, Proctor was looking for and then found and sent Anna's photos. Do you have any confirmation of that? I mean, if that can be proven, that's explosive, says Ashley Lauren. Oh, thanks, Cindy, for buying me 5 matcha lattes. You are so sweet. Says, thank you for always clarifying court filings. Calling me a beautiful young lady with a wealth of knowledge. Oh, you're crazy. Young lady. I bet I'm older than you. But thank you, Cindy, so much for your kind and generous matcha lattes because I like them better than coffee. Look at Danny coming in. The details. All the details. Let's see what we have here. This is Cohasset PD. Thanks, Danny. Erin also sent it to me. That is the also Cohasset P. I'm looking for specifically right now for purposes of this stream, if there's any Proctor investigative reports. Okay, then there's some documents regarding, that's the federal case. Okay. That's the federal case about his financial crimes. And then, I mean, you guys are really on top of it. I can't even believe it. US v. Walsh, that's the other stuff. Yeah. But I was specifically looking for purposes of today, if anybody had it, and we probably can't find it right now. We'll do it another day. Any police reports of the actual Michael Proctor? Thank you, Texie, for buying me 3 matcha lattes also. You're so sweet. DC, just remember, it's a team, not an individual who makes up a team of tainted players. No, I think he's arguing you do not get a taint team. You gotta turn it over to the defense counsel. We know how to protect stuff. We are in the best position, according to the case law of Massachusetts. We are in the best position as the defense team to look and see what we think is relevant and what's not, because we know this case better than anyone, right? And we will protect anything that doesn't have anything to do with our case. So you can't just hide behind, your taint team. Just because you want a taint team doesn't mean you're going to get it. One need look no further. No. So did the feds turn over two related files to Walsh's attorney too? No, we're going to have to come back on December 2nd. Mark your calendars at 2 p.m. That's when they're going to argue it. We're going to come back and Judge Bev is going to be there. And we'll see what kind of sartorial splendor Brian Walsh brings with him this time, because he was dressed real nice. He looked totally different than he did in his earlier videos. Go back and watch my first stream on that if you haven't seen it. We looked at a lot of video from when it first happened. I think we looked at his original pleading not guilty in court. He has been held in Norfolk County Jail, or whatever the local jail is in Norfolk, since his arrest, all the way back in, how long has it been? 2023? Thanks, Janai. 2023? But his case law is 100 years old? No, it was just that one quote. Oh, is case law 100 years? No, he was just saying fox guarding the hen house. That expression has been around for 450 years. Oh, you said 100 years old. I don't know. I don't know if December 2nd, is it the same, it's the same jail where Aiden Carney was? And somebody says December 2nd is the same day as Aiden's hearing. I don't know. I don't know, but you know what? Is that at Norfolk Superior? Because then we're going to have a full day of court hearings. We probably can go right from like Aiden's hearing to Walsh's hearing to Turk's hearing, because I don't remember when Turk is coming back. Danny says, one would think Bev, thank you, Danny, for your emails. One would think that Bev would be tired of cleaning up their mess already, but nope, she's happily protecting Mars. That's what people think. That is your opinion. 13 King says, him and Aiden, Brian Walsh and Aiden both stayed in medical together. Aiden spoke with him. That's crazy. That's crazy. Glare said something last night on his channel, and I correct me if I'm wrong, that he had a conversation with Kevin Reddington when he was in court one day, when Will was in court one day, and that Kevin Reddington is representing, the guy Turk, Dr. Turk, who cut up his wife, and that he had a little funny exchange with Kevin Reddington about who he was representing that day, and it was kind of funny. I'm not going to repeat it. You can go watch Will's stream to find out what he said, but it was funny. He said that Walsh was creepy as F. Really? It was the same jail he wanted Turtle Boy to write his story? Jerry? Walsh's story? Wow. Turtle Boy did not speak with Walsh. I don't know. I'm getting all Turk. I don't know. I don't want to spread misinformation. He was near him in that jail, so I'm not going to spread misinformation. But what I'm going to do is thank you all for coming to hang out with me today, for the time that we dug up the rug in the backyard of the TikToker in Ohio, hoping there was a body there, thinking there was a body there. We were so invested in that earlier today. And now people are thinking she made it up for clout. I don't think that. I don't think that, Team Brittany. Do you think that? I don't think that. And I would really hate if the online trolls start going after this poor girl, who I think needs to change her username on TikTok and Instagram, and are going to start showing up at her house yelling at her that she made this up for clout. Yes, Kim, we covered this. That is what we are talking about. That's exactly what we went over. First thing, Kim, if you weren't here earlier, rewind and watch, because what we did was, whenever the filing of the Norfolk District Attorney's Office that said they don't plan to call him, and also that the first document was they said they had his cloud data and his all of his the extraction of his phone, and they didn't want to turn the whole thing over. They want to taint team, blah blah blah. So that is why they made this motion. That's why on the 24th of September, Larry Tipton, one of my new favorite attorneys in Boston area, made this motion saying, you don't need a taint team under the case law. You need to give it to us. We decide. Make sure to remove the glare from the rug, says Scott Messerschmidt. Scott, were you blown away that you sent me that thing? Email me, because that was crazy what you found about that sheriff. I mean, about that other person named Mullins that happened to be in the same paper. Or is that why you sent it to me? I'm still confused. All right. Thanks, mods, for another great stream today, for hanging out for another 2 hours and 10 minutes, for being so kind, cool, and classy, as always. My friends, my chatters, my channel members, thank you so much. And, just do the things. Do all the things that YouTube likes for me, please. It helps push the stream out. Share the stream. like the stream, comment on the stream, be nice to each other as you have been so kind to each other throughout the pendency of all of these cases that we watch together. Be cool, be kind, be classy. Yeah, they do face disciplinary. Oh, sure, if they make up police reports, it's criminal. It's they could get decertified, as we saw happen in another police officer's case recently. The twin brother of Farwell. Yeah, it's criminal. It's disciplinary. It's a lot of things and stuff, Mike and them. Thanks for hanging out with me today, you guys. Go watch Aiden's trivia show. Well, wait, should I teleport you guys somewhere? Hold on. Hold, please. Let me see who's out there right now. We can do a cupcake invasion because that's the nice thing to do, isn't it? It is the nice thing to do. Tell me. Do you want me to teleport you over to Turtle Boy's trivia night and then you guys can hit your, I don't know what time that is supposed to be starting. I don't know what time it's supposed to be starting, but I will transport you over there because so many of us should be in this trivia game because we would win. I know we would. They're having teams of 6 and they're doing like Canton Turtle Boy trivia night. So, he knows I didn't block him. You guys, that was all manufactured beef, not by him, but by other crazy people on the cesspool of Twitter. Oh, El Jefe's coming on, but isn't he members only? And so those who are not members won't be able to see it. All right, you are going on over. That's right. Auntie Bev's verdict form. That TikTok could have also happened to any one of us while building a fence. We could have came across a rug buried in there. I don't think that she did that. And I hope that people don't go after her, but you know how they are. When I hit end, you are going to be teleported over to Turtle Boy's trivia stream. His stream tonight is open to all. Oh, you guys, we already decided to go to the trivia. What time? Well, is Sean coming on first? What time is Turtle Boy supposed to start? What time is the trivia game happening? It doesn't say. Oh, that's at 8:45. All right. So you know what we're gonna do? We're gonna go to. I don't know why Sean's isn't coming up on my thing. Like, why does that not coming up? It's not coming up. I'm looking under like mofo. I'm looking at going through the motions. I don't know why. Maybe he doesn't allow people to redirect to him. That could be why, you guys. I'm sorry, but it's not coming up. So I will tell you, go watch Going Through the Motions, aka Sean McDonough at 7. And I'm going to redirect you over to Turtle Boy, okay? All right. So tell him Cupcake Invasion. There's no beef. I'll see you later. Bye, Kelly. Bye, Kelly. He doesn't know it's a thing to be able to redirect. Yeah, you can only redirect. I did. I put my fan base at mlittlelaw.com is my email. I put it up earlier in the stream. If you rewind, it's on the stream. Okay. So Sean probably doesn't know that he has to allow people to redirect to him. You're going to Turtle Boy. Tell him Cupcake Invasion. Make sure everyone on his Twitter knows there's no beef between us. There never has ever been. We don't even know each other. So there's that. All right, you guys. Peace. Make sure you're subscribed and hit the bell because you never know. I go live on a whim oftentimes. Bye.